Margaret. Dr. Hunt, you'll be aware that at meetings of this committee we discussed the issue of EBS with the tied agents, and that has gone through the courts, through this committee, and it is continues to be an issue that's raised here with the committee in terms of the advance that we're making to try and assist with a solution. And I know that in 2019 the High Court Judge Jordan, I quote the following, said, "I would have thought that a competent mediator would bring sense to bear and mediate a solution to the dispute between the parties. And if the parties are committed to doing business with integrity and in accordance with the regulatory requirements that exist, then what possible obstacle stands in the way of both sides starting on a new page, even if some rearrangements and compromises are required to both sides?" The High Court judge continued that large banks and financial institutions and smaller ones wish the public to forgive the past and to move on with a positive attitude. They should lead by example. What the parties have enjoyed in business together ought not be lost if it can be salvaged. The exercise in itself might serve to help restore the public mind, the trust, confidence and faith that they should have in banks and financial institutions, and which is now being slowly rebuilt with effort over and above any required to solve this ongoing dispute. That may be a high-minded and naive recommendation, the judge said, on my part, but it is something I would urge on both sides in any event. So that's what the judge said. I'm inclined to agree with the judge. And I would ask, arising from that statement and the time that has passed, what efforts have you made to, understand the message that the judge was giving and to resolve the issue with the EBS tied agents?
Thank you, Chairman. EBS has been part of AIB Group since 2011. It's a different model in terms of how we engage with our offices to the rest of the group. We have 68 agencies, offices around the state. It's a very important part of the group. It's a very important part in terms of the delivery of mortgage product to our customers. And we have excellent relationships with the vast majority of our agents. I and all my colleagues are fully invested in the success of EBS and the success of those agents. But in the context of an EU restructuring programme where we were required to shut 20 of those offices, we've issues that you refer to, but I'm going to hand over now to my colleague Jim O'Keefe on this topic.
To go back before Mr. O'Keefe comes in, because you're the CEO of the bank, and I want to know what your attitude is towards what the judge said in 2019, and if there is any room for mediation. Mr. O'Keefe may very well be familiar with the detail of it, but in terms of getting to an end on this, I think it's only fair that we would look to the judge's word and quote and determine if the bank is willing to come to the table in terms of mediation.
Chairman, I am deeply conscious of the need for this bank to put legacy issues behind it, for once and for all. I want to see us moving forward, but we are in litigation on this topic. That is a simple fact, and I am not going to go beyond that at this juncture.
Do you see mediation as an option?
We are currently in litigation on this topic, and I'm not going to go beyond that.
Yeah, well, litigation is probably, a couple of steps beyond common sense, whereas the judge rightly points out that mediation might be an option. And I'm just asking you, would you consider mediation? Your answer seems to indicate that mediation is not an option, and you're going to litigate this out to the end. And I'd remind you that some of those that appeared in the public gallery here on the last occasion that this was debated at length by this committee have since died. So they haven't lived to see the outcome of the efforts that they were making to find some sort of address for this issue. So I would have thought that the common sense approach, based on what the judge has suggested in the High Court, that mediation would be an avenue that you might pursue. I mean, have you even thought about it? Has it been discussed by the board or discussed by your management team? Or is it completely off the table and you're hell-bent on litigation?
Well, I wouldn't use the phrase hell-bent. This has been discussed on a number of occasions in appropriate forum within the organisation, and we will do what is in the best interests of all our stakeholders in this particular regard.
And would you consider that the EBS tied agents are stakeholders?
Yes, they are, but we have got to take into account the views of all stakeholders.
But in taking their views into account, would you not consider that a meeting for the purpose of mediation and the fulfilment of the judge's direction, if you like, is worth considering?
But, Chairman, we are currently in litigation. That's the position we're currently in.
There's nothing to stop you from reversing out of it. If the will is there to do it and you want to deal with legacy issues, I would suggest that both parties could very easily stand back from the litigation and attempt to mediate. In most cases, in fact, now, particularly to do with banks, judges often point to customers and banks going to mediation to resolve issues. And it seems to be a very sensible approach, and it has worked. So again, I'm pressing you to consider what the judge has said in terms of mediation. And if you don't wish to answer that, you might tell me then, having been in the High Court in 2019, where else is there to go?
Okay, so maybe, Chairman, if it's okay, I'll come in there, Colin, just on the
yes,
topic.
Mr. O'Keefe.
Colin said that this is an issue that has been discussed. I think, look, for the purpose of this afternoon, we have to be cautious on the fact that clearly, as Colin has mentioned, from our stakeholders' point of view, we can't prejudice any ongoing litigation. So, any commitments that we would or inadvertently make this afternoon that would prejudice it, we clearly have to avoid. And in terms of mediation, as the committee will know, we use mediation on many fronts because we have been working with customers over a long period of time, especially customers in difficulty, and we have worked through mediation. So I think, Chairman, there's no question mark as to whether we would use mediation in particular scenarios or not. But this afternoon, I would ask that we're not at liberty to commit to using mediation in this particular instance. I think if. But certainly I'm certainly willing to take that away and look at the legal side of it and see where that would leave us. But I would have to just refrain from making the commitment that we would enter into mediation. This has been, and I can't go into the details of the case. Clearly, you've had the opportunity to meet with the agents on this side, but unfortunately, I can't. It's not our policy to disclose, as it shouldn't be, any details in relation to these items. But as you're well aware, this is a very complex and long-running issue, and the course of action that has been taken in this is as a result of all of that. So It's not an unwillingness on our behalf to try and close issues of the past. It is bedded in the issue of the complexity and indeed some of the circumstances of the case. So, but notwithstanding that, I certainly, and myself and Helen will look at what impact it would have if we were to consider anything at this point in time. But that unfortunately, from a legal point of view, is as far as we could probably go today.
Is the case before a particular court?
Yes, it is. Yes.
Which one?
Yeah.
Is it a Supreme Court or?
So the next phase of that case, in terms of where it's going to, it's in Q3 or early next year, I think, is the next phase, and that's back in the High Court, as I understand it.
You'd hardly go back to the judge, Jordan, in view of what Judge Jordan said. Sorry?
February 22 is due back.
It's due back in court?
Yeah.
Okay. Well, I again just want to say to you that the committee members here will be monitoring that situation, and I firmly believe that in dealing with legacy issues, the bank should be to the fore and not be afraid to deal with them. Whether that's taking all stakeholders into account, because I'm not saying that it's something that is absolutely that the law is on the side of the EBS. I'm just saying that common sense would dictate that people that have a grievance should at least try that process. And I think that that would be not just my opinion, it's obviously the judge's opinion as well. So I'd ask you to take note of it and hopefully to deal with it in that way.